So we are live now on our YouTube channel. We will be starting within a. We shall wait for 1 or 2 minutes and then we shall start. Okay. So hi everyone. I am Nidhi Chiller and I welcome you all on the behalf of the Lexpeeps family. Lexpeeps Pvt Limited is an organization that works to assist and help law schools in organizing and managing their events. We are seeking to provide young and dynamic law students a platform to experience the legal world in the academic capacities. We organize different events where budding lawyers can experience the legal world. With a self directed educational strategy and the guidance of industry experts, LexPeeps also provide you with the recent happenings in the legal world in the form of news opportunities where you can find what suits you the best, articles to explore your interest, and many more. Keeping practical exposure for the law students in mind, LexPeeps provide you with internships where the legal experts and budding lawyers come in touch with each other and grow by associating with the company. The sole purpose of LexPeeps is to provide law students and law schools quality and to create value to the legal fraternity. Today, present with us is Miss Shruti Kapadia. Ma'am is an arguing counsel, certified mediator, and a policy analyst. She has judged various moot courts and also trained students for mediation. She is also a sports enthusiast. I welcome you, ma'am.
Thank you so much and good evening, one and all. It's my pleasure to be on this wonderful platform today. So I hope we'll make this more informative and useful for our students here.
Definitely. So, in today's session, Dhruti ma'am would be talking on the different facets of litigation, arbitration, and mediation. Ma'am, before beginning, I would ask you a question. What is the basic difference between litigation, arbitration, and mediation?
So basic difference would be the remedy I choose as a litigant. Do I opt for litigation? That is, do I want to go to the courts and really litigate against the party who has deprived me of my ABCD rights, or I have been aggrieved by his acts? So then I go to the court and I have my legal remedies and I want to file suit. I want to file writ petition or I want to file a PIL or whatsoever remedies I want to go against him to get my reliefs. Now, whereas arbitration would be a concept of alternate dispute resolution. It's not that I want to go in the court. I want to resolve my dispute, but in a way, amicably, by keeping a neutral person in place who will be like a judge, or rather, he's a tribunal, or they could be tribunals where we have two or three arbitrators. We have three arbitrators. They can never be a like even number of arbitrators. They sit together to decide whether A or B's claims are correct or not correct, or what damages they could be getting forward on. So basically, what I'm going in a very layman concept of the talking conversation here, just to make you understand what is the difference. If I go to the court, I have to file litigation suits. If I go to the tribunal, I have to select my arbitrator being parties, where both the parties agree, yes, we want this person to be our arbitrator to adjudicate our disputes, where whatever he or she would be passing an award would be final and enforceable in law. Whereas in litigation, we have the orders where we can challenge, and that is a decree. If that is so the case, depends case to case of what we get.
Okay, ma'am, I want to ask is there any difference of technique as well that is required while practicing the litigation, arbitration, and mediation?
See, when you ask me practicing as a litigation, the technique is how you present your case, before whichever forum. So difference would be there. In court, I'm in an aggressive mode. I want to fight to get my rights clear. In arbitration, I will go step by step. I'm putting my case before a neutral person who's an arbitrator, where we are having a private venue, not inside the court, where we'll say, look, this is what our claims are, this is what our written statements is, this is how we want to proceed with. And the technique there would be is a flexibility of time. It would be the days we choose as parties. In courts, we get the dates as per the court's desires to give us. So this is something that we say, the time flexibility. The speedy remedial option we have in ADR, that is in mediation as well. We can decide upon who the mediator would be, and we will select the times as parties of where we want to have a venue and how we want to proceed. The procedural part of it is completely how the parties want to go ahead with it. But in litigation, we have the civil procedure code, we have the criminal procedure code, the techniques that are very procedural, which we have to follow. And as in when we have in Bombay the High Court rule books, we have the appellate side books. We have to follow those procedure. In arbitration, the procedure is not per se very restrictive and very strict in that sense. It's flexible. So the techniques here would be, the counsels would be very brief. A CPC and evidence point of view will not be really completely followed. It's a flexible option. Whereas in court, we have to follow these procedures completely.
So if someone wants to have a speedy trial, if someone wants to, I'm sorry, if someone wants to go for a speedy trial, so one should go for arbitration rather than going to the courts as it becomes more hectic.
Now, look, I'll tell you, a client comes to me. I'm giving you a couple of examples to give you a wide understanding of what I mean to say. A client comes to me, he or she says, I have a dispute with my real brother. And I would say, what is the dispute pertaining to? Is it pertaining to the property? Is it pertaining to ego issue of defaming each other in the family surroundings? Depending on what the issue is and what is the best method which would help them resolve the dispute amicably, I would select an option. Maybe mediation would be better, not even arbitration. I would say, let's try to mediate. Let's try to see if we can have a private mediation. If not, if we are litigating in the court, then court would say it's a blood relation, it's two brothers who are fighting. Why not we have a mediator appointed who can resolve your disputes? If that doesn't work out, obviously you have a dispute here to go ahead with the court. So what I'm trying to say here is, depending on case to case, which is the fastest method and a suitable method would be the option we should guide our clients. What happens many a times, we say, oh, come on, you go and litigate. Litigation takes years and years, rounds and rounds of litigations. Arbitration, we have limitation within 1.5 years, we ought to finish. So it's a good option if we have the clauses in the agreement that we can evoke arbitration. Go for that. Particularly, it depends case to case. How fast we do it, it's also upon the willingness of the parties. I'll give you a reverse example. Many times when litigations are ongoing litigations are going on, there is an option which falls from the bench sometimes. Why don't you try mediation? One party really wants to go ahead and try to mediate. The other one says, okay, fine, let us just say yes, because we just want to delay the process. So mediation then fails. It's not enforceable. So they do this tactics either to delay or either to fast track. There is the other side of the coin where we can say, yes, this litigation will go for 20 years. I want to mediate, I want to settle, want to come to amicable point. If that works out very good for us. So it's case to case, very speedy, fast track disposal. If I would say, obviously I'll go for ADR system. That's the concept. But sometimes in ADR also, in arbitration, if 1.5 years gets over, people go for extensions of time. So it's again on the party's motivation and the deliberations of how you conduct it all. Sometimes what happens is parties want to go ahead. There is a fallout of, even the tribunal where they cannot persuade you to whatever reasons, and there could be a drop off of delay. So delay could be anywhere. Fast tracking is on the means and the eagerness of the parties. Litigation, you really don't have that prevailing option because it's bulk and bulk of litigations. It's not private in nature. It's like dates on dates as and when the courts want to do it. So it's quite different. That's why the option is ADR, which we want to avail and we want our clients to benefit from it.
So, ma'am, we have a question coming from the audience. That is, why arbitration don't cover the divorce matter in arbitration? Like, why isn't divorce proceedings included in arbitration?
There are exceptions in the act itself, like divorce matters are there, landlord tenancy matters are there. So we have a separate statute itself which doesn't cover in the particular format of the arbitration act civil commercial disputes which are in nature. Those are the ones for which this acts are there, like basically. So What happens if I want to settle a dispute? I will not go on a matrimonial forum to go and directly file a suit or against the party or litigate. I would rather opt for mediation. So that's the other wire media where we have a counseling center, we have mediation options also available. So that's where we have the differentiations of it. That's a good question from the audience. Why we don't have? Because the statute itself is like a model law book, and we have those principally commercial litigations which are covered to back off it in an arbitration format.
Very well explained, ma'am. Ma'am,
Thank you.
all these three, litigation, arbitration, and mediation, has its own charm. But what do you think is going to grow exponential in future?
This is like you are putting yourself into a flipping of a coin. What is the best? I would say, what is your interest? If your interest is to litigate, you want to present yourself before the court and get orders from the court, you're a litigating counsel. But I would say, I just don't like court, but I want to argue, present my case, be convincing, the same thing what a counsel does, but before a private forum. I would say I'll go for mediation. Is my flexibility, it's upon the sessions we carry on, it's my choice, I'll go ahead. The career in mediation and arbitration would be fantastic, particularly when you have to see the future lawyers coming in. Crores of cases are pending in India. Why not we try to bulk off the pilings of the cases in the court and take it forward and inculcate our techniques of pursuing the arbitrator and mediator and getting relief faster for our clients from a forum which is not inside the court, which is outside the court. That's where I would say mediation is also picking up. So many youngsters are like, okay, we don't want to wear this black and white coats and go up here with the band and all there. Let's be like corporate look. Let's go before the arbitrator. Let's go before the mediator. So it really works out. Sometimes why people don't really feel satisfied in mediation, I would say, and they would say there's no point doing mediation because the enforceability comes into the play. They're like, we're trying so hard, but ultimately one of the party may say, we're just backing off. We don't want to do it. Like, how do you hold this? In arbitration, is enforceability is there. It's good. Mediation, in some cases where we have incorporations of the law, where pre-litigation has to be mediated and it would be enforceable and binding, but there's no force. Litigation orders are binding. So again, if the rounds and rounds of litigation you enjoy as a career maker, try that. But if you say I'm fed up of this court proceedings, because people do get a frustration point at times when they don't get reliefs fast, assignments changes, the technical reasons happen. So they feel we don't want to do it. In one date, you will not get the order immediately in the court. But in mediation, just take it a case where I'm sitting in one session, my ego breaks as a party, even his ego breaks. We can settle the dispute in a very common way. So it's again how you want to do it.
Okay, ma'am, we have another question coming from Sumit Jain from our
Gee.
audience. He's asking, I'm still confused with conciliation and mediation sometimes. So he's basically asking between the difference between the two.
See, conciliation in some of the statutes, we have these options where the court will say this is a conciliator appointed, we want to settle the dispute, and this is what will be binding. Whereas in mediation, it's again a private choice. Even if there's a court annex mediation, you have the opportunity to say, look, it didn't work out, the report failed. The mediator will put, the court appointed mediator would say, I'm putting up the facts, what I have heard, and this is the report which I'm telling the court it failed or it succeeded. It's again like how you make an attempt. Both of them are more or less similar, but the enforceability is where we drop off in mediation.
Very well explained, ma'am. Ma'am, my question is fresh graduates usually do have a plenty of roads to walk further, right? Like what course they, where they need to further, where they do practice, right? But if we stick to these three options, like litigation, arbitration, and mediation, so which one ensures a better career? It is something related to my earlier question. So, what do you think is going to ensure them a better career? Like we
See,
know arbitration is really
this
growing
is like
nowadays.
no, your question is like we are trying to see who's the lucky charm.
Yeah.
It's like yeah, see, you try litigation, you may just passionately love it. Then you are like, I'm just loving the court. As I again say, the better career for students nowadays, if they want to do an international platform growing thing, I would say arbitration and ADR is very good because as a certified arbitrator, or if you take some international courses in arbitration and mediation, which will not be investive of a lot of time, you can practice even internationally. You can get a brief of international arbitration, which is lucrative, which is sophisticated, which is well polished, but you need to go through the phases of it. Just a fresher cannot say, oh, I'll take up this brief and I'll do it. You need experience. Litigation also, you need a lot of experience. The more you appear, the more you learn, the more you fail, the more you succeed in the future. So it's like that. So you have to navigate. I would say mediation is also good for women, particularly if they want to practice in. I'm not going on a gender base. What happens is many females want to have a career where they don't want to be much seen in the court. They want to have flexibility because of their marriage life or whatever they believe in. So, like, I'm not going there on that platform, but it's more flexible. It's my choice what I want to do. Even some guys are like, okay, we want to part time, we do it. Like, it's more flexible for us. So mediation is also a good career because you have your own sessions fixed, your own schedule fixed. But in court, you will not have that fixation of the times. You'll have to go through when the dates are there. You will have to appear because you are there to argue before the court. You cannot tell the court, I cannot come today. But in mediation, you can tell the mediator, I cannot come today. So it's more flexible. If you ask me flexibility point of view, where I ask like what you want to do, if you want to balance both the lives, it's good to go for mediation also.
Ma'am, what are the different skills that are required to excel in arbitration? Like, are there some skills that are eventually required for an arbitrator to
You
be an
have to be
arbitrator, to be a
very,
good arbitrator?
yes, you have to be absolutely non-partial. You have to be non-biased. You have to be very, very observant. You have to be very neutral. As I repeat the words bias, neutral, you have to have the skills of patient hearing. You cannot sometimes the both the parties are talking something which is not really there. You should know how to drive it and say, look, I don't see this is your pleadings, stop there. So you should have the skill and knack to control the parties also in a limited way. You cannot dominate it, but you have to control it in that way that the arbitration proceeds, there are no personal allegations. So it has to be, there's no conflict of interest. So one has to be very careful while they're taking up the arbitrator briefs, because conflict of interest should also not be there. So the skills are very much as you would be as an advocate, or you would be as much as a sitting judge. You have to be neutral, biased, no influence, nowhere, just what your brief is there, what you are hearing, and what the evidence they are leading, you pass the hearing. This is how it would be. You can take some personal courses if you like to get trained of how to write an award, how to write a foreign award. So we have a couple of institutions where we get these trainings options. So once you get theoretical training and then you go in the pool to practice, you will realize yourself to really principally act on those things what you are learning in theories.
Very well said. Ma'am, do clients' expectation changes with a change in the area of practice? Like, do they change with, if I am practicing litigation, they do have different expectation. If I go for arbitration, they might have different expectation from the arbitrator as well. So how can one satisfy client alongside serving the best of justice?
See, you cannot restrict yourself firstly that I'll only be an arbitrator or I'll only go and practice. It depends what the matters come to. You cannot say, okay, purely I'm just not going to go to the court. What if you get the client who gives you a brief, and attorney gives you a brief as a counsel to go and argue in a court? So why should we restrict? The expectations of the client is that there should be justice done if they give it to you. Be honest with them, you give them the right opinion, and you give them the right fee structure. So you have to be very, very neutral, see that there's no conflict of interest, and with ethical skills you are working. So in both the ways, expectations as your questions are, whether in litigation they would have a different mindset about you, you're already recognized as something after the years of practice you are doing. For example, Dhruti Kapadia today, who's talking to you, would be known to see more in the courts than just being an arbitrator. So they're like, oh, she's also a counselor, she's arguing. So clients are well read in the market about who is what. So the expectations are already there in the mind, therefore they're coming to you for that. So it's like we have to do our job, what comes to us. We don't have to be bothered of what people want you to do. You have to do what you can do.
Definitely. Ma'am, we have a question coming from Radha Chaudhary. She is asking, what is the future and scope of arbitration, especially in India?
It's excellent because Singapore is the hub of arbitration. India, we have many institutions like MCIA. We have a couple of institutional arbitrations. We have NST arbitration. We have a lot of those things. So I think it's excellent, and I would say game in for it, because if you can do arbitrations, you have a luxury of how you want to practice.
Okay, ma'am. Very well explained, ma'am. If our audience have any question, then you can please put forth your questions in the chat box.
Okay, there are some questions in the chat box. You can take up whichever you like so we can answer accordingly.
Yeah, ma'am. I just have asked. I think I have covered every question. I believe so.
There is this one question: what is the future and scope of arbitration in India? So we've answered that. It's a good scope. So India is a hub, business hub. So wherever there's a business hub, there are commercial disputes, and I believe arbitration can take a very good peak role both for the arbitrator as well as the clients who want to get the fast track disposals of the matters.
Okay, so I don't feel so. We have some other questions coming from audience.
Yeah.
Uh, Ma'am, thanks for being with us, and it was really a wonderful experience to hear from you. And I once again thank you from the whole Lexpeeps family. Thanks for
I hope
this
I've
wonderful
given
session.
some inputs. Not that there have been a lecture series per se, it's a question answer series, so we've just been bang to the point. But I hope I've been able to satisfy a few of your queries to a limited extent, definitely, because we've not been going like a lecture series here. Thank you so much for inviting me, and it's my pleasure to be there for the students always.
Thanks for being with us, ma'am. And if anyone has any questions to be asked from ma'am, you can please drop your comments, and we will then share it with ma'am. Is it right, ma'am? Will you be able to
Yes,
answer them?
why not? Why not? Thank you so much.
Okay, ma'am. Thank you so much.
Thank you. Bye bye.